Did I share with you my horror at looking like Greg Wallace?
Get recognised.
I joined a video conference the other day and I suddenly saw myself on the screen. I thought, oh my God, they must be thinking Greg Wallace. But
You should change your name, Will. Just not Greg Wallace.
I could, because Michel Foucault, people don't know who he is, but I like to think I look a bit like him.
Oh, Michelle Foucault. Yeah, he's a colourful character. You right, guys? So we're just getting ready as always. Just kind of got clicks and buttons in the back office here. Welcome. Whilst I'm doing that, here we go. Right, I think I've done everything. Oh, I've got to do one more thing. Oh, I've already done that. That's weird. How did I just manage that? Anyway, cool. Yeah, welcome to this week's live stream. We've had I think 5 questions come in through the week. So if you have a question, put it into the live stream chat, but put it as if it's about a hypothetical person. So start your question, what if, and kind of work out from there. So and also what else I want to say, it's not legal advice. So we're doing our best here to give you some useful information. It does work sometimes, but obviously it's not going to be foolproof because it's difficult to kind of relay all the information we need from you and you need from us. But it's hopefully going to get you in the right direction. And again, if you just put, yeah, cool. How you actually that? You are Ains. Yeah, we'll get to those questions. Let's start with the ones from the week that are anonymized, and we'll do them first, then come into the live stream then. So, and you have to forgive me, I've had a ridiculously busy week, so I'm all over the place, but I'm kind of getting there. So here comes the first question. Any gossip, by the way, guys? Any sort of notices or anything like that? Anything that's happened? I did see some interesting LJ decisions this week, but I didn't have time to look at them. There's one from Manchester, like one of the first ones, and it was basically just like where Manchester, I think, had accepted that the person's TA was not suitable, but they hadn't moved them, and that's basically not okay. As soon as the council recognises it's not suitable, then they have basically an immediate duty to put you somewhere that is suitable. But anyway, but there's probably some others as well. So yeah, just if you haven't already, go on the LJ website, ljo.org.uk, and subscribe to the newsletters. I think you can now specify that you just want the ones on housing and homelessness rather than all the other ones. So yeah, it's a really good resource. But anyway, so first question that we've got tonight that's coming through the week, quite a long one, but I think I've scanned through it earlier. I think it's kind of reasonably clear. If someone is owed the main housing duty because of vulnerability, and he's offered accommodation, either temporary accommodation or private rented sector offer to end the main duty out of borough and far away from support system, despite undergoing long-term psychotherapies that cannot just be transferred and restarted somewhere else, and getting PIP mobility as they cannot undertake any journey because it would cause overwhelming psychological distress, so they cannot travel far away to get regular therapy, and also having doctors' letters supporting the danger of the subject of interrupting therapies. Can they refuse your accommodation because unsuitable if out of borough, as it would make them unable to continue the ongoing therapies? Or do they have to accept the offer of accommodation and then challenge the suitability, having to interrupt therapies meanwhile they're living, that's all happening? What about if, for example, they receive PRS offer and they have to sign a tenancy, either 6 or 12 months, and pay a deposit, knowing already they have to challenge the suitability of the accommodation since it will make them unable to continue to attend ongoing therapy? So really good question. There's a number of things that kind of link in here. So I think if we just start with the last bit, because that might be the simplest just to kind of eliminate. So the idea that, when you accept an offer, you have to pay the deposit. Now, I don't actually know if there's any, you guys can fill in if there's any bits of law, but certainly my experience with councils is that they, by definition, they won't expect you to pay the deposit because you're, unless you've got really good financial situation or something. The point of them securing these types of offers is that effectively it's suitable and possible to move into. So unless there's some unusual kind of financial arrangements here, as in the applicant has got lots of money available, then I don't think the council would insist you paying a deposit. That's certainly my experience anyway. That's in one sense why you have these rent deposit schemes, because the council effectively guarantees the deposit amount rather than the person have to pay it. But again, other councils might do that differently. I don't know. I'm not sure if there's anything that kind of specifically says whether they can or not. But I think pragmatically, councils would just try and, the point is they want to get you in somewhere to kind of end the duty to you, and they're willing to pay hundreds of pounds for that to happen. So I don't know. Yeah, you guys, have you got anything to kind of add or to take away from that bit of the answer? Because I think if we just kind of break it down like this. Yeah, and then kind of get onto the meat of it. So, if we kind of return to the main bulk of the question, so we have someone who is fairly likely that this psychological issue is going to constitute a disability, the definition of which is where the impairment has a substantial long-term impact on someone's ability to carry out day-to-day living activities. So, and the fact that that someone can't travel because of the overwhelming psychological distress, then we're almost certainly, as in like 99.9% talking about someone with a disability. And what that then means is when the council discharges any duty to someone with a disability, they need to be able to prove how they carefully consider that person's disability in working out whether the property was suitable. And I would say, from a legal point of view, it's probably going to be quite straightforward to challenge a decision like that. Although, as I often say, much easier if you've got a solicitor. So at this point, I just want to bring the others in just to see what they have else to say about this particular element of it before we look at the sort of the other part, which is should the person accept the offer and then challenge it. So we'll kind of deal with that a bit last. But in terms of the kind of the principal law bit of this, Will, I don't know if you want to start us off by just explaining how council should consider a situation like this and whether essentially it's reasonable for someone to say this isn't suitable because of the impact it's going to have on my treatment. So yeah, start with you, Will.
Well, the legal position is that they obviously have to make sure the accommodation is suitable, and they have to go through a checklist of a number of different things like affordability and suitable. And this would come under suitable on medical grounds, I guess. But the difficulty is that the council will will very often take a sort of default position, which is, of course, we've taken it into account and we still say it's suitable. It's not really an open debate that you have with them. They'll just say, we've thought about it, or worse still, we've run your situation past our medical advisor. And they say that there's nothing special about your situation, which means you need to have the therapies. So then the problem then is you're faced with a sort of very difficult choice, because the question isn't, do you have to accept it? Because you don't have to accept it. But the question is, what are the consequences if you don't? Which you may think, well, that's just a different way around, but it isn't, because if somebody offers you accommodation which there is just no way you could accept, and you could never live there, you're not going to accept it, even if somebody says, well, we say you should. So the worst case scenario there would be that the council would say, well, we're going to treat our duties towards you as discharged, and we're going to cancel your temporary accommodation locally, or we're not going to give you any temporary accommodation if you were waiting for this. And then you'd have to face the prospect of being street homeless. So what you'd then look to do is challenge that. And there's a number of ways you could do that. You could go for a review of if it was temporary accommodation, you'd go for a judicial review of the suitability of the offer or of the decision to offer it to you. And if it's non-emergency temporary, it's section 193 temporary, you'd go for a review. So it's either a judicial review or an internal review. And then you could ask for an order requiring the council to house you while that's all going on. So there is a possible way to avoid the worst case scenario, but it's all going to turn on the evidence. And I hate to say this, but what somebody says about their medical condition is a long way from what a judge may accept if their doctors aren't prepared to back them up. And it's quite a common problem that somebody will say, I have a medical issue, and then they can't produce any medical evidence. So it's best to make sure the doctor's online. But I mean, in a situation like this where somebody's undergoing treatment locally, and that is and it's important treatment, then the more important the treatment and the impact of the disruption, the stronger the case is. But it's really difficult to say. I mean, if I was advising a client, I would say, well, if possible, accept it and then go for a review, even if you have to interrupt the therapies for a bit, which is better than having the offer withdrawn and then having to sort of fight for temporary accommodation later on. Sorry, that's a very long, rambling
Just,
answer.
I've just got a couple of, well, certainly one question on that. So if someone signed a tenancy as, and this has been given as a final accommodation offer or something, and then, so then they win the review, but the fact they've signed a tenancy, how does that work? Do they kind of, how does that tenancy end? Does the council do some magic with it, or is it something else?
Well, if it was a council tenancy, that would be easier because the council could say, okay, we accept that we shouldn't have offered you this, and we will agree to accept a surrender of the tenancy if you want that, and we will write off any rent that you owe us. If it's a private sector tenancy, it's a bit more difficult because you signed, the council aren't in a position to terminate the tenancy. But I think you could say, well, I'm not going to move in there or I'm going to move out, and the council would be liable, arguably liable for the consequences. You'd have to make a complaint. It's a messy situation because if the private landlord said, well, you've made a contract with me to pay rent, and so I'm going to take you to court, it might be possible to join the council in and say, well, I only accepted this because the council made me do it, and therefore they should pay me. But legally, I mean, that's not a particularly strong legal argument, although it's a very strong moral one. So the best thing would be probably just to make a complaint and say that as part of the complaint, the remedy is to have to be indemnified and to basically for the council to pay whatever you owe as a result of them giving you an unsuitable offer.
So, I mean, just to kind of, I guess, reflect back what you said there, Will. So, in one sense, a situation like this is going to probably hinge on the quality and the detail of the medical evidence from the supporting doctors. Now, let's say someone's getting, say something like DBT, so what is it, dialectic behaviour therapy, which certainly is technically available in the NHS, but you have to wait years for it, and that's actually kind of got some good outcomes from it. I would have thought that someone delivering that therapy might at least write a letter saying this is the person presenting issues, and this is how long it took them to get, kind of actually receive the treatment, and this is what they might expect to actually, if they were to transfer to 100 miles away, this is how long they'd have to wait to get it again. And my experience of therapists would be that they wouldn't be kind of going out, speaking out of turn to give that information. That'd be very straightforward to give. So, and I just wonder then if this then therefore becomes a situation which would benefit, or essentially would, in practical terms, really benefit from having a solicitor involved. At which point I'd say Virgo solicitors, which contact details are on Will's website. I'll put the link in the chat in a little bit. May have capacity. It's kind of like they're kind of fluctuating off and on, but they may well be worth giving them a ring just to see, see if this case can be taken on because. Yeah, if as a non-solicitor, I would have thought there'd be quite a lot to go on if the evidence is
Yeah.
obtainable.
And it does turn on evidence which you may not be able to get as a member of the public yourself because a lot of people want paying for writing reports. So maybe your own doctor or therapist or whatever might be able to do something for free. But if you need, I mean, ultimately, this might turn on getting an independent psychiatrist report, which another problem is you're not going to get that. It takes weeks to get a psychiatrist report, and this is needed urgently if you're facing a decision. Yeah, I mean, you definitely need this. I mean, you benefit from having a solicitor doing this sort of thing. I mean, one
And
of the I just find the problems are that medical people don't like getting drawn into these disputes, and so sometimes you just have to get independent ones.
yeah, um, yeah, I would also again speculate that a lot of councils, as soon as a solicitor is writing to their legal team and raising these questions, they would very quickly back down and try and find something more suitable. But yeah, I think I'm not sure if we can go any further than what we've said there. Carol, so Shannon, have you got anything to add to that at all? No, yeah, okay. So I mean, I'm hoping that, as I say, I'll do the link out in a little bit to stick in the chat, which is on Will's website. There's like a list of legal aid funded solicitor firms, one of which is Virgo's, which potentially might have some capacity at the moment, although that might get snapped up very quickly. So that's our first question. I think there's one more question from the week that was anonymized, so we'll do that one next as well. And then we'll get on to, well, there's two more that are anonymized before we get into the live chat. So question 2 for this week is, What if your council has repeatedly failed to engage with irrefutable medical evidence in two different cycles of stage 1 and 2 reviews, when my friend clearly qualifies according to their housing allocation scheme and the ombudsman won't hold them accountable? How can you force accountability to reverse the decision if they are breaking their own rules? Thank you. Also, when on the precipice of having a response of the stage 2 review and can't wriggle out of awarding, how can they prevent, if council suddenly decide to offer another type of accommodation that's still temporary, having to start a new points application? It looks like a manoeuvre to delay awarding medical priority. They want to move single mum and child in year 11 GCSEs with January exams on Boxing Day. So no internet, etc., violating child's rights of access to educational resources and have Christmas. So um, again, we just have to break this down. I just might pick up at the end here and say, I'm not quite sure when you talk about child's rights to access educational resources and have Christmas. I don't know which of them, whether either of them are actually rights in the sense that they're legally enforceable. I might be wrong, but yeah, and I'm sure it is going to certainly come into kind of the idea of promoting the welfare of the child, but I'm not quite sure whether there's any sort of standalone kind of right to have internet access for a kid, even if it is just coming up to their exams. You might just, as I say, have to kind of tackle it as a more broader welfare issue. Now, just to kind of try and pick this, I have a feeling we're going to have to speculate on the question here because there's a few. I'm trying to interpret this. I'll try and interpret. Well, I'll try and say how I think I'm interpreting this. So where it says, um, first of all, we're talking about points. So that says to me this is actually about a Part 6 application rather than a homelessness application, which might actually be why the ombudsman, and I'm going to guess here, local government ombudsman, because bearing in mind there's actually many ombudsmans, well, certainly more than 3. So there's local government ombudsman, which deals, well, so let me just be really kind of pedantic. There's the local government and social care ombudsman, which used to be called the local government ombudsman. So it's now called the LGSCO. They investigate Part 7 and Part 6 issues with councils, among other things as well. You've then got housing ombudsman, which might kind of look at something like the quality of temporary accommodation. But I'm going to guess we're talking about the local government ombudsman here. Now, it's possible, and I'm not familiar with the Part 6 kind of aspect to what the ombudsman does, but I'm not quite sure if they have the same ability to investigate and make recommendations when we're talking about a council's own policy under Part 6. So whereas Part 7 is always the same, Part 6 is different, and there's a kind of different review structure, and so I'm not quite sure the ombudsman has the same ability to kind of cut into things. Shannon?
I've interpreted it only slightly differently. But I think obviously the points and stuff is Part 6, but it sounds to me like they've made a Part 7 application purely because they've talked about offering another type of accommodation that is still temporary, which says to me they're in temporary accommodation. But do you know how obviously when you make a Part 7 homelessness application, they'll put you on housing register, and often you'd get housed under their allocations policy, even though you're Part 7. And I would guess that, like you've just said, they've gone to the ombudsman about the Part 6 housing allocations and their internal like policy of like points and whatever, and the ombudsman can't comment on that, but it's still a Part 7 application. It's just what accommodation they're being offered
Yeah,
potentially.
yeah. I mean, I guess be helpful just to kind of ascertain what kind of understanding of this is. Again, this kind of idea of having irrefutable medical evidence. Again, that doesn't you might have irrefutable proof that you've got one leg, but that doesn't necessarily mean that there's an irrefutable argument that you're in priority need. Now you probably are, but it's not the same thing as kind of being like one, A equals B. So
And I think, sorry,
that's right. Yeah, go for it.
I think a lot often on the allocations policy, I've certainly seen it where you could have like loads of medical things wrong with you, but with the allocations policy under Part 6, often it's about whether it affects your housing, which is why often they use like accessible accommodation or medical needs rather than sort of like priority need and stuff. So you could have lots of medical evidence, but you still might not tick in the allocations policy the medical band or get enough points because it doesn't necessarily affect your housing. Um, and just to add as well, I did quickly Google the child's right to access educational resources. It does look like it's enshrined in the United Nations Convention on the Rights of a Child. But if I was putting myself in the shoes of a housing officer, I would say that, well, actually, it's Christmas holidays. and they're not in school, like it's not term time. If I was going to be really, really like cynical and mean about it, I guess. So yeah.
Yeah. So I think we'll circle back around, because I think there's a whole we haven't kind of really got into the kind of the duties under the Children Act and those duties to promote the well-being of the child. But but I guess I just want to, if we can kind of establish what we think we're talking about here, because I'm just trying to think why the Ombudsman wouldn't hold them to account. One reason would be is because there's a number of reasons why the LGO won't kind of intervene. One is that the complaints policy hasn't been exhausted yet. Another is that it's out of time, which this won't be because this is obviously in time. It might be because I don't know, the kind of the thing that's at stake is a legal decision, and the Ombudsman won't look into the kind of the actual decision itself. So you might have a complaint that the council ignored medical evidence and found you not in priority need. The LGO could look at the process of what inquiries were made, what medical evidence was actually kind of obtained, but they wouldn't be able to say the non-priority decision was actually wrong itself. That would have to be through the court system, the kind of the court process. So how do you how can you force accountability to reverse a decision? So I guess there's a number of elements you need. One is you need to be legally and technically right. That's the important thing. So you need to kind of understand the kind of these different nuances to how evidence is taken into account within Part 6 and Part 7. And once you know you're right, you then need to have potentially a solicitor in some situations, because you need to go through the court process, or it might be you just need to have a knowledgeable advocate. What I would say at this point is that involving councillors might be helpful at this point. There's nothing to lose by involving councillors and the MP. There's a chance that they do nothing at all and they're useless, but there is a chance they'd also be helpful. And again, it just depends on the council and the councillors that's there. So, and again, just because I'm a pedant, and I guess it does help to be pedantic here. So, stage 2 review, does that mean stage 2 complaint, or is that kind of? I mean, I'm not quite sure what that'd be, because
I'm not sure.
is that the kind of is that challenging the points on the housing register policy? Because again, that might have stages set out. I mean, we haven't said it yet. Part 6 policies are different in every area, so there is no kind of universal. Whereas Part 7 is universal, or certainly applies to the whole of England. So I know that I'm just kind of like dithering about here, but I'm just trying to work out, okay, what might be the issue here.
I think the person who's asked this question, I think, is in the chat, Ginger. Because they've said it's LGSO living in a hostel for 10 months and the council's not followed protocol and not engaged with evidence, child under CAMH for severe anxiety.
Yeah. So I mean, well, I guess that straight away there, hotel with children out for 10 months is definitely black and white a failure. But so the only reason the LGO wouldn't kind of get involved in that would be because you haven't exhausted the council's complaint process yet. But again, I'm not quite sure. Two cycles of stage 1 and 2 reviews, is that complaints? I'm not quite sure what that would be. But in terms of if you're just looking at that length of time in a hotel, just making a very short stage 1 complaint, getting a response, making a very short stage 2 complaint, assuming the council's policy only has 2 stages, which most only do have 2 stages. If you then went to the LGO, they will uphold that complaint, because it's black and white. This family have been in TA for longer, or in hotel accommodation for more than 6 weeks. So I'm just making sure I'm not getting mixed up here. Yeah, hotel. Yeah. So okay, it might be we can kind of just eke out some more detail on that. Let's just talk about this idea of kind of the kids' GCSE exams, because and the fact that the child has potentially got some very severe anxiety. So, and again, Will and Karis, this is your bag more than mine, but I'll try and just give us a sketch out of the situation. First of all, within housing law, within Part 7 of the Housing Act, which is all about homeless applications, it does specifically talk about suitability or location of temporary accommodation, and school, and basically, particularly exam years in school. So I'm just actually going to get that. I'll get the code of guidance up just so we can kind of look at it together, so you can see what I'm talking about. So again, and you can just Google this anytime. It's just if you just Google Homelessness Code of Guidance, you'll get this document. These are just a list of amendments, and then this is kind of where it actually starts properly. And if I just search for the term GCSE, pretty sure there's only one reference to it in the whole thing. So chapter 17, paragraph 55. When securing accommodation for families with children, housing authorities should be mindful of their duties under Section 11 of the Children Act 2004 to discharge their functions with regard to the need to safeguard and promote the welfare of children. This would include minimising disruption to the education of children and young people, particularly but not solely at critical points in time, as such leading up to taking GCSE or their equivalent examination. So that's exactly what we're talking about here. So we go January exam. This is obviously going to be disruptive. I'm just seeing if there's anything down here. There's also stuff around kind of like distance and kind of time of travel, but yeah, I'm just trying to see if there's anything in 17.56 that might help us out as well. Yeah, not directly. So you've kind of got this kind of argument from the education of the child, but you've also got potentially, you know, the additional thing of the anxiety of the child as well. Will or Caris, so I'm going to pick on you because you're solicitors. How would you kind of approach this kind of issue of the kind of child's education and location of TA? And just as an additional comment in the chat, just saying that there's been a team family meeting. So I guess that would maybe team around the child. I'm not sure. Experts have asserted that the child should not be moved over this period. Child psychotherapists, etc., ignored their recommendations. I'm not quite sure what that means. So child psychotherapists ignored their recommendations, ignored the family meetings. Okay, so there might be some kind of contradicting medical evidence as well we're talking about here. But yeah, I mean, let's just start with the kind of the basic principle when it comes to location of temporary accommodation and housing and children in that, particularly that year 11 GCSEs. How should councils treat that? Do you want to have a little go, Will?
Yeah, sorry. My understanding is that they shouldn't rehouse children so as to disrupt those exams. So that would be a strong argument that the accommodation was unsuitable. I'm sorry. I mean, I'm sorry I can't say more than that, but
yeah. So and I guess like obviously because time is of the essence. I'm just wondering, like I've talked about involving counsellors, and they can be really helpful. But I think involving counsellors and explaining what the law is, and kind of even if you're just sketching this out, and even if you're just quoting that paragraph of the show that's a 17.55, and kind of emailing the counsellor or the MP or everyone is probably a better way of doing it. So any counsellor who's relevant plus the MP, and just saying, look, this is what the council's trying to insist on, and these are the reasons why, why you don't think it's suitable, and seeing if you can get it resolved, you know, now, as in like, you know, within the next few days, rather than having to go through that process over Christmas, which, you know, none of the housing officers will be at work over Christmas probably. It just ain't going to get fixed in that way, and you're going to end up in January, and you know, obviously the child's exam results are going to be affected by it. So you know, again, I would imagine that having a solicitor involved in this kind of situation would benefit that person. Just to kind of navigate all this stuff and potentially to put medical evidence together. So there's just been clarification in the chat saying that the child psychotherapist and the other experts all agree it's the council that's ignoring the recommendations. So I would imagine that if you start pulling that apart within a, you know, kind of a judicial review or something, it's going to fall apart quite quickly for the council, and they're going to go back on it. So yeah, going back to kind of try and clarify what we're saying. I would say the law is on this person's side 100%, but the challenge is how do you get the council to actually follow the law in this timescale? And I'd say get a solicitor. So again, I still haven't done it yet. Let me get. In fact, if something you can just Google it yourself. You Google Will Flack law. So I'll just do it now. Just put it up there, and then
it's W Flack.
wflack.com. Then
I'm not sure.
Well, you've got a slight problem with the kind of the website's gone a little bit weird with the way it's laid out, but it's still navigable. But there's kind of like a pop up that comes.
Oh yeah. Sorry, is that does it go straight to website scores?
Yeah, so it's kind of, it just obscures some of the stuff behind it.
Sorry, that's not. I don't know why it's doing that, because that's not the. If you just click on where it says, "What do you?" Oh no, it's not even that.
Yeah, you can get around it.
To that. But if you go to, oh yeah,
I'll put it in the chat. So if you just go to that link I put in there, you'll get the listers, and I suggest you start by ringing Virgo out of that list.
Yeah.
and see what can happen. I mean, it sounds like there's probably already quite a lot of evidence already that exists that's going to be useful. So yeah, I'm not sure if we can be any more helpful in the live stream, but there might be some stuff there that if you get in contact with Virgos, it might work out. So yeah, I fear that as I say, even if the law's on your side in that situation, the reality is that by the time the council actually deal with it, then it's going to be messed up anyway. But certainly when this person gets the headspace, they should really pursue the time in hotel accommodation, if nothing else, because there's first of all 10 months. What's 10 months? So what's that? 8.5 months. So my math is terrible. What's that? 34, 36 weeks in total, £100 a week at least. So 3,600 at least, up to £200 a week. So between, you look at something like 5k compensation just for that. And if you're kind of thinking, what the hell am I talking about? If you go on the local government and social care ombudsman's website, lgo.org.uk, and browse their decisions, there are decisions which are upholding exactly this issue, because the code of guidance is very clear. Councils cannot house families with children or pregnant women in hotel accommodation for more than 6 weeks, and if they do, then between 100 and 200 pounds is the going rate per week. So check that out as well.
To say on that, compensation doesn't affect your benefits. So if you are on universal credit or getting housing benefit or anything like that, compensation wouldn't be taken into account. So you don't need to worry sort of on that side of things. And there's been a follow-up question. Does judicial review fall under legal aid, and will it be possible in time?
So again, Will, you can answer this better than I do, but I think yes and yes.
Yeah, I mean, the good thing about judicial review is that it does come under legal aid as long as you've got an argument, a strong case, and or at least a 50% plus case, really. And it is a very fast remedy. You can literally get, it takes a while to get the papers prepared to go to a judicial review, but you can get an order the same day as you issue the proceedings. So it is a good remedy. The only thing I'd say is if the council are expecting a family to move on Boxing Day, I mean, that seems unrealistic of them to expect a family to move on a public holiday. But also, the question is, if they don't move, probably nothing's going to happen until about the first week of January. I mean, obviously, there's a danger that the council may then say, we'll treat our duties as discharged, etc. But I can't see that anybody from the council is going to come around on Boxing Day and say, right, and they shouldn't anyway, because presumably they'd have to get a court order to get you out. No, sorry, it's hotel accommodation. I apologise. So if you're in a hotel, yeah, you're in danger that they can just cancel the booking. So yeah, that is a problem. So you would need to get a court order to prevent the council from, or to require the council to either extend the booking or house elsewhere.
I mean, just to emphasise, it is plausible in this timescale to get it all sorted. So when let's say a solicitor has got capacity, then there's some forms to fill out. They'll have to kind of make sure you are eligible for legal aid. But if you're on universal credit, it's a given, and if you're on low income, it's possible as well. Once that paperwork's submitted, it's then relatively quick. So I'd be fairly confident there would be time for a solicitor to move in that time. Easy for me to say that, but yeah. Cool. Okay. So yeah, hopefully there is some useful stuff in that. Apologise, we can't be kind of more helpful, but yeah, I guess it's giving an indicator of what you might be able to do. Question 3. This is almost anonymised. I've seen it's not quite anonymised, but it's good enough. So my sister-in-law was given Section 21, but was told not to leave by the council. Now she has received a letter from a landlord saying he has taken it through the court and given her a bill of £430. She's lived in the property for 7 years, always been a good tenant, 70 years old, is in poor health. As much as the landlord wishes her to leave, she in turn wants to leave, but the process is so slow. My question is it correct that she has to pay the landlord court fees up front? It might as well be 430 million. The poor lass is penniless. Thank you for your time and patience. So I'm getting some vigorous shaking of the head from the others there. So does someone want to just say, answer the straightforward question, but there's a little bit more to say about the whole Section 21 and being asked to stay past that date. So can the landlord ask for an upfront payment of £430 for court costs? Anyone want to go for it?
Yeah, I mean, I'll go for it since uh, I'd say the landlord can ask for it, but they're not entitled to it. What if the landlord wants to recover any money from the tenant as a result of court proceedings? The landlord has to get a court order requiring the person to pay those proceedings and then enforce it. So if the landlord wants to go to court, the landlord's going to have to pay the court fee, otherwise they'll never get the court action issued. They can't, I mean, they can't ask the tenant to pay £430 up front. I mean, I thought it was going to say the landlord says, I'd like to go to court, but I can't afford it, but I will if you pay the issue fee. But it's not saying that. It's saying he is going to take it through the court, so he'll have to pay it himself. But he's given her a bill for £430. That doesn't sound like a legally enforceable bill to me. I don't know what the 430 covers. It might be the court fee, but obviously the court fee would only be recoverable if the court ordered it, because it could be that the landlord's case gets thrown out, in which case nothing's recoverable. So no, the answer is she doesn't have to pay the court fees up front or at any time until ordered to do so. And even then, they've got to enforce it. I've been doing this job for 30 years now, and I've never come across a case of a landlord of this type of case of somebody coming. I mean, it may happen that people don't come to me about that sort of problem, but I've never had a case of somebody saying, "Oh, the landlord's taking action to recover the money from the court case," because usually, once the landlord gets a possession order, the tenant, by definition, moves out at some stage, and then the landlord's got to find them. And usually, if somebody, as in this case, is penniless, if the landlord tries to enforce it, they're not going to get anywhere. I mean, they could, in theory, send the bailiffs round or try and make the person bankrupt. But actually, for £430, you're not going to be able to make anyone bankrupt. So lawyers have an expression that if a landlord went to a lawyer and said, "I've got this tenant and I want to claim £430 from when I took them to court," I mean, don't let's even go down the road of asking for it up front. But at the end of it, the solicitor gets a possession order and gets an order for costs, and then the landlord says to the solicitor, "Right, let's go and enforce that order." The expression is throwing good money after bad, and the solicitor will say, "Well, okay, give me another £1,000 and I'll have a go, but I can't guarantee success." And if I was you, I would just write it off, because you've avoided a nightmare because most landlords trying to enforce a Section 21 will be that grateful if they get a possession order rather than a long court case with hundreds of pounds of legal fees based on a technical defence or worse, a counterclaim for damages for disrepair or something. So I think that there's very little chance of that money ever being recovered. But sorry, that's a long answer, but definitely nothing up front is payable legally.
No, that's all helpful. Thanks, Will. Karis, did you have anything to add to that one?
No, sorry.
Cool. So I've just put into the chat like a link to a video I did, which kind of we'll briefly talk. I know the question has just been quite specific. There's a bit more to say. So I've just put a video into the chat, which is a video I did, which is about kind of being asked to stay past the expiry of the Section 21, and basically how councils can end up having to pay compensation and the court fees as well. So have a look at that video. But just to say as well, just to kind of, again, it's just helpful, just information as well. There is no age at which you're automatically in priority need. However, a 70-year-old pensioner who's in poor health is almost certainly going to be in priority need. Again, you have to argue it through vulnerability, so there is a bit of a job to do. So just, one sense, I would say there's one thing that could be done here is that the sister complains to the council saying, "Why are you advising me to stay past the end of the Section 21 notice?" It's pretty clear the landlord is dead set on getting the eviction through the courts. So there's no prospect of me staying here. So essentially, that therefore goes against the code of guidance. And in that video I've just posted, there's some links to some LGO cases where there was compensation to both the landlord and to the tenant when a council asked them to stay past the Section 21 expiring. So just bear that stuff in mind as well. But even if even if the eviction happens, it is highly likely that this lady will be in priority need. She will not be intentionally homeless. and therefore the council owe her a main duty. And most councils, when it comes to over 55 or over 60 age accommodation, you can walk into it. It's generally there's no waiting list at all, or if there is, it's very short. So I'm hoping long term she could actually end up in a better situation of being in a private rented accommodation. So just kind of bear all that stuff in mind. Obviously, don't kind of do a bit more research on it, but that gives you a bit of a framework of what else you might want to look into. So we're going to right. That's all the anonymized questions from the week. So we'll get them to the other ones at the end. We just go back over the questions from the live chat. So okay, I'm not sure if we're going to be
Mike, can I just interrupt and go back to that question? So if your sister-in-law had the council look at the Section 21, did they say because sometimes they will talk about if the Section 21 is valid, so kind of look at why they told her not to leave. Start looking at a homeless application because she's threatened with homelessness through the Section 21 because she's got the notice, and making sure that's a live application, just so council can't just push her back.
Yeah,
that's all.
No, that's it's a really good point. I mean, so I mean, if the council was to look at the notice and realise it was invalid, then actually what they're saying is right. But I don't read that into it. This one, again, if you go on this YouTube channel and search for the best way to make a homeless application, I go through the steps you want to be taking to make sure, as Kara said, the actual application has been accepted and the council has processed it properly. It involves kind of emailing it and just making sure you're using the right language. Question from the week, question from the live chat. So following up on a question I asked last week, the council is saying to talk to the tenancy management to get, okay, it's not anonymous, but I missed it anyway. So is it a good, I'll rephrase it in a minute, is it a good sign that the council are talking to the tenancy management to get the name taken off? I'm not sure if we can know for sure whether it is or not. I guess the kind of the question would be, well, what are the council advising about what's going to happen to this person? So, it's unlikely the council are going to help you become intentionally homeless. That'd be really stupid. But you probably do want to get it in writing. What are they going to do once your name's off the joint tenancy? So that would be my answer to that one. I'm going to rephrase it in a minute just to kind of make sure it's anonymized. So just to reiterate, guys, please put questions in the third person. It causes problems for me. It means you have to put your personal data on the internet, and actually it can often confuse issues rather than kind of actually focusing on the legal bits. So I know I sound like an absolute pedant, but it's just the way it is. So do you guys have anything to add to that one? I'll rephrase it in a minute.
No, I don't.
Just bear with me, I was going to change it. Now I can't spell because people are watching. There we go. Right, someone's not yet. Cool. Okay, so next question. Someone saying thanks from help last week. Someone's got a relief duty. So next question. I think it's a multi-part, so I'll just make sure I've got it all loaded up before we start tackling it. By the way, very welcome. People are obviously very, very welcome to ask questions in the live chat. If you ask questions in the week on any in the comment section of any video, you don't have the word limit, so you can just ask questions all in one go. Just a little benefit of doing it that way. So I think that's all of it. What if someone's son receives disability living allowance and is in nursery that supports his development? Should they put in the housing plan agreement unsupported needs that their child stay in the area to attend school under Section 11 Care Act 17.55? 17.55. I think that's reference back to the code of guidance when we talked about kind of school, kind of location school and kind of crucial exam years and stuff. Or shall they just accept the housing plan agreement and dispute if they offer private outside area school under the Section 11? Okay, kind of that same reference. Or shall they just so I've just copied and pasted the same bit twice, haven't I? Just let me get the actual right bit, that last bit. I think this is following on. I think I'm getting this right. What if someone has been given has been given housing association websites in housing plan, but it's out of the area. Can they request housing association websites that are in the surrounding area? So, okay. So the question, I guess, and again, everyone else correct me if I'm wrong here. My understanding of the situation would be is that whilst the son may have a disability and have additional needs, the question would still be, well, okay, are there nurseries in another area that would be able to meet that child's needs? And the answer might be no, it might be yes. But effectively, the nursery and any plan in place around the child there, I guess there might be some children act stuff involved potentially. There would need to be some specific reason why the move, why that child needs to stay in that particular nursery. And I guess, arguments can be made about how they're getting on and stuff, but you probably need some very detailed evidence to sort of say that they definitely need to stay there. So again, guys, do you just want to kind of jump in there with what I've just said in terms of correcting me or adding to that element of this question? So in terms of the need, kind of trying to evidence the fact that this family need to stay near the nursery rather than the surrounding area. Does anyone want anything to change in what I just said? Because if not, I'll just go to the next bit. So, okay, or shall they just accept the housing plan agreement? So the answer is no. Your housing plan, you want it to be as detailed and as accurate as possible, and you want to raise everything you possibly can at this point. So it should have been a collaboration. You should have actually been sitting down with the housing officer and actually doing the housing plan, the personalised housing plan. Often that's not the case. Often they just kind of do a template and just send it to you and say that you did it all together and you didn't. But yes, so you want to be challenging the personalised housing plan and saying, you need to be aware of my son's particular needs and this is what they are. And here's some evidence from the nursery and maybe the doctors or whatever that say that this child needs to stay in this area to enable them to access this particular nursery. Assuming that's the case. So absolutely get the personalised housing plan up and running and make sure it's completely accurate and you're completely happy with all of it. Because although you can challenge things later, they can be a little bit like, well, why didn't you tell us when we were doing the personalised housing plan? So that's what I'm going to say about that element of it. Again, guys, have you got anything to add or take away from what I've just said in that bit? No, okay. And in terms of being given housing associations from other areas, just bear in mind that lots of housing associations cover multiple areas. So it might be, you've been given, I don't know, whatever, Peabody's website, and Peabody are based in wherever they're based in, but they might still have housing stock in your area. So it's not necessarily a bad sign. If you're in London, though, and you're looking at, I guess, at least here a 2-bed home, you're looking at years before you're going to get a house through social housing. So although they might have given you some websites, that doesn't really have necessarily any bearing on whether you're going to get social housing. You might get private rented somewhere. And in terms of can a council request housing association accommodation in another area? I guess they can. I don't know how that would be managed. Certainly, councils can technically ask another council to cooperate in discharging, a duty to someone, but the other council can refuse, so it doesn't happen very often. But certainly, there are some housing association kind of waiting lists and registers that are cross borders, so that might happen as well. Again, I don't know. I'd need to know kind of what the actual situation was for that one. So yeah, I don't know. Again, I'm not sure how positive all that was really, or how helpful it was. But I think what you want to focus on is, if there is a particular reason why the son needs to be in that particular nursery, then you need to get some smoking gun evidence of that being the case. And, potentially if the social worker is involved, from them, from the nursery manager, if there's any kind of medical intervention or treatment going on for the child, then getting it all together. And again, a little bit like the kind of case we were talking about before, whilst councils can disregard, they can, they're physically able to ignore medical evidence. If a solicitor was involved, they're going to make kind of mincemeat of the council's position, because the council legally need to show how they took that information carefully into consideration when they arrived at their offer of a suitable accommodation. So yeah, guys, you want to add anything to any of what I've just said there? Because this is not. I've only had limited experience in cases like involving this sort of thing, so, and I kind of often I'd kind of deal with it by just throwing the kitchen sink at it, involving councillors, involving MPs, and just kind of making the moral argument rather than necessarily a technical legal argument.
Could I just add that I think this is a really important, it's an important question in that it identifies the need Well, it raises the issue of the housing needs assessment, which I think I talk about every time I get the opportunity, because it's so much more important. If you're going to have an argument about suitability, it's much more important to have it at the assessment stage than it is at the offer stage, because you can actually criticise them much more easily for not doing a proper assessment, and then they can't then come and it's easier to challenge suitability later if you say, well, I told them at the time of the assessment that this wasn't a good assessment. And they should be they should be working with the family to identify what their housing needs are rather than and that's what they should do at the assessment stage. At the offer stage, it just becomes about the council trying to defend the suitability of the offer, which is a sort of defensive action rather than a working together action. But the problem in reality, I think, is that councils haven't really taken on board the implications of the Homelessness Reduction Act, which, if you think about the way that housing lawyers and people like us and people advising homeless people work, is that we try and take a sympathetic approach and say, what's a good solution for the problem you're facing? How can you get out of this? Now, that's what the council should be doing. They should be sitting down with people just as sympathetically as us and saying, well, we'll talk to so and so and see if they agree with this about your son's needs. And we'll try and get a report from them. But instead, the assessment is almost all, I mean, it's very rare you get anything approaching a half decent assessment under the Section 189A. And the personal housing plan is usually just something that's run off the word processor, and it could have been sent to anybody. And it's usually sort of, if you look for somewhere, we'll support you while you do that. And it's nothing more than that. So it's easy to challenge those things, I think. But again, it helps if you've got a lawyer. But definitely don't leave it until they offer you something unsuitable. Have a go at challenging because there's two ways of challenging it. The assessment you would challenge by way of judicial review, and the personal housing plan, which followed that, you would challenge by way of an internal review. So you can get the internal review off straight away.
I mean, I'd also say that potentially you wouldn't, if you wouldn't necessarily need to do it formally, you might just email the housing officer and say, hang on, you've missed this completely. Could we have another meeting to kind of discuss it further? And I think any sensible housing officer will say, yeah, okay, sure. So yeah, although there are those kind of formal routes, then there are the informal one as well. Shannon?
Yeah, I can't remember if I've just spaced out and you've already said it, so apologies. I know, and we know we talked about it for a previous question, but did you mention like disabilities for this one? Just because even if it's not the main applicant who has the disability, so say in this situation it's your son, and they're still part of the household. So the council would still have to consider that disability through everything they then do. And I'm not saying they definitely have disability, because you could be on DLA, I think, and not have a disability, but it would be quite likely that whatever's going on for that son, that they do have a disability. So it's worth just laying that out and laying out all of his sort of support needs that might affect housing or could affect his schooling as well, and location and everything like that, because that will just strengthen the housing plan agreement.
Yeah, cool.
Another point to add, sorry, is that a child with a disability is by definition in need for the purposes of Section 17 of the Children Act. And so the Children Services Department would, if there was an issue here, should be required to carry out an assessment as to how to meet those needs in this particular situation.
Well, are you able to the local authority's duty to promote the welfare or the well-being of a child? How does that then kind of come into their decision making within the Housing Act? So how does when a housing officer
Section 17 or under Section 11?
I don't know. I mean, I'm not familiar with the Children Act particularly, other than kind of knowing a few little bits here and there. So,
without going into too much detail, I think it's Section 17 says that, or elsewhere in the Children Act, talks of a need to promote the well-being of children in the area. Now, local authorities seize on that and say that that's just a target duty. It's just motherhood and apple pie. Everybody agrees that children should have a nice time, but it doesn't give rise to any concrete rights for the children to actually have their well-being observed. That often gets shot down quite quickly because it does give rise to right. If a child's well-being or development is likely to be impaired as a result of something, or if they are already disabled, then they are in need. And the council has to, I mean, the council could say, yes, we recognise that this child is in need because they're disabled, but we don't think there's any problem at the moment facing them. But they would have to get round that. It comes up a lot in dealing with families who have no recourse to public funds because they have to be housed by children's services. And if a child is facing destitution because they have no income and no housing because various governments thought it was a good idea to exclude them from that, or their parents, then they have to go to children's services and say they're facing destitution. Now, you sometimes get barristers standing up and saying, well, the children have no more right than to, like everybody else, to be taken into account generally. But it's wrong, and they do have. I've forgotten the name of the court case that says it, but it has. The bottom line is it has got teeth, that duty. They have to promote individual children. It's not just thinking nice thoughts. And also, Section 11 is very powerful because it says that it goes a step further and says that in all of their functions, they have to make sure that the well-being of children is protected. They're powerful weapons.
And I mean, so again, this is way outside my area of like knowledge, but so the function of providing suitable housing would come under that duty. What you just said there in terms of the need to protect the well-being of the child. I mean, I think I'm thinking back to the YR case, and that was kind of part of it where that was what was supposed to be in the assessment, was how the children's well-being and stuff would be affected by the move, 90 minutes away or whatever it was. Karis, sorry, just very quickly, just in the chat. So I put the link to literally if the person who's asking about the list of solicitors. If you go to the link I put in there, it should take you straight there, I think, rather than kind of navigate it.
I'll just do it now.
But so yeah, Karis.
Council tell me to go away until the bailiff comes knocking.
I'm sorry, I clicked your video there. That was the wrong link. But it did work when I tried it earlier.
Yeah.
There is a High Court case that and it's ZRR versus London Borough of Bexley, where the assessment was unlawful because it failed to assess the educational needs of the child. That would be.
Yeah, in fact, that's my case.
Yeah. Oh wow.
Hey. That was one of mine, and that was where they said somebody applied to Bexley after they'd been found intentionally homeless, and they had children with special needs, and the council said, all right, we'll send you off to Manchester for a month. How about that? And they hadn't done any inquiries into how the needs would be met in Manchester. And they tried to argue various sort of things like, it doesn't matter, it's a general duty, it wouldn't have made any difference, but they lost. So yeah, that was a good decision, that one.
Yeah.
I didn't know Greg Wallace was a solicitor. Hey, right, Tiff. Don't need to apologise for being late. So I forgot to say hello to Cheeseface as well. I'm sure Cheeseface is in tonight.
I thought Cheeseface was in earlier.
Cool. So again, we're not. I'm not doing. Don't feel I'm doing a very good job of giving people sort of, really kind of hard and fast, black and white stuff that you can go away with. But I'm hoping again within that discussion there's some stuff which is useful, even if the outcome is you probably really need a solicitor in that situation. And just Ginger, just let me know if that link still doesn't work, because I've just tried it mine and it seems to go straight to that page. And just to bear in mind, guys, so whereas Will's put the location of the different firms, now that we're in the world of Zoom and kind of everything's remote, they can cover anywhere. So you don't need to be in North London to get North London lawyers. So question 6, no, it is question 6, but my copy and paste function is still not working. Let's try that again. And I think is this a multi-parter? Maybe not. Let's have a look. So are review officers who look at original decisions actually trying to follow that lawful decision has been made, or looking for more reasons not to help someone? Great question. The answer is sometimes yes, sometimes no. So in Bedford, we're blessed at the moment with having a decent review officer, but they have not always been decent. And who will quite freely say when they think the frontline housing officer's decision is awful, and they'll correct it. But that's not always the case. So yes, some council review officers, they're specifically there just to defend the first decision and, you know, be even more perverse sometimes. So yeah, that's my straightforward answer to a straightforward question. If you guys have got anything to add to that, go for it. If not, no, cool, okay. So next question. So yeah, let me just go back to question 6 briefly. So all you can do is still make the best argument you can at the review stage, and that doesn't mean to need to say you've got to have a 10-page long review letter, review request letter under Section 202, but just kind of just try and make your points, bullet point them, just make it, or not even better, number them, and just kind of try and focus on where you think the original decision didn't take the right information into account, or it kind of misused information. Yeah, rather than kind of making a moral argument, because moral arguments won't work in this situation. They need to be kind of really based on legal issues. Question 7, what if a housing needs assessment was never done? Good question. So just to give you an idea when the needs assessment needs to be done, you can make a homeless application either when you're already homeless, or if you are threatened with homelessness, which means you're likely to be homeless in the next 56 days. In both situations, as soon as the council is satisfied that you are indeed homeless and you are indeed eligible for assistance, or you are indeed threatened with homelessness and you are eligible, at that point, they then have this duty to carry out a needs assessment, which has to look at why you lost your home, what type of accommodation you need, and what support you need to maintain it. And that then kind of feeds into the personalised housing plan. So they have to be done. It's a legal duty, even if they're just a template bit of bit of writing, which doesn't actually mean a lot in the real world. And you can get compensation just because a needs assessment was not done, even if it had no further impact on whether or not you're housed. So it might be the council don't do a needs assessment, but they house you anyway, and actually you might be very happy with that house. The fact that they didn't do a needs assessment, essentially the way the LGSEO would look at it, they'd say, well, that actually gave rise to unnecessary uncertainty and distress, and they would give you a payment of maybe £100 or £200 for it. So the one option is to complain. However, we've talked about it before on the channel where sometimes complaining just pisses people off and makes them be really nasty. So you might be better off in the short term just by saying, hey, housing officer, you're really lovely and everything. I don't think you've done the needs assessment, or I haven't seen it. Could you please look into it to see if that gets them to actually do it? But just bear in mind, it doesn't directly lead to a roof being put over your head necessarily. So it's kind of, I think sometimes you've got to pick your battles, and sometimes you just wait until everything's sorted out afterwards, and then you kind of go back and complain about the things the council did wrong, because you not only might get a bit of compensation, but you also are likely to push up the standards within the council and mean that other people get a better service. So yeah, so Tiff, I'm hoping it might be you've written that question after I said what I said, because there's like a 30-second lag. So just to reiterate, a lot of those solicitors, certainly Virgo is the example we've been talking about tonight, they have the capability to work anywhere in the country, as in England. I don't know if they work in Wales, but
Virgo's not on that list though, just as a
I think it's down towards the bottom. It's the last, it's like so it's on the North London.
The very last one on North London.
Yeah. So yeah, that's they can still work, yeah, using phones and video calls and everything to get their work out. Yeah, so next question. So guys, I'm probably going to call time on new questions in the live stream from now on. We've still got a couple to do from the week. So number 8, what if someone emailed caseworker about son's need to stay in specific school, but they ignored and only sent relief due letter along with a housing plan with no regards to what was said? So again, I guess just to kind of consolidate what we've said, you really need to have like evidence from the different professionals, which might be the case. It might be this person already has that stuff. The fact that the housing officer has just disregarded it in their housing plan, I would say probably the sensible thing to do in the first instance is go back to the housing officer and say, look, hey, you know, you seem to have missed out some of the stuff I said. Can you amend the personalised housing plan? If they ignore that, or if they refuse to, then I'd start complaining at that point and just say, this is really important. it's clear that the council need to have taken that stuff into account, and they haven't, and it's clearly going to have a bearing on what sort of accommodation is, you know, deemed to be suitable. So that would be my stage, my kind of way. But then, as Will said earlier, it would be possible to actually get a solicitor involved even at that stage to kind of get them to sort that out through judicial review proceedings. So, cool. I think that's everything I can see in the live chat. So as I say, we're going to call it time. Guys, if I'm not sure how useful it has been this week, but if you have found it useful, please do like the video because it just helps with the algorithm. And if you haven't subscribed to the channel already, please do, because you'll get notifications of when we go live and new videos and stuff like that. So if we go back to the final 2 questions from the week, some interesting ones actually. So and one of which will lead on to, I think, a video we need to do kind of standalone. But anyway, so number 9, how about if you find it difficult writing email? I'm currently suffering with glaucoma, with partly blind. Thanks. Okay, so, and I think this question's in regards to dealing with the whole bureaucratic process of making a homeless application or making a housing application. If you're partially sighted and you haven't already, you need to get an assessment from the local authority under the Care Act, because you probably have care and support needs which could be met either by the local authority or by a local charity or something. So Bedford has got, what's it called, Sight Concern, I think. I don't know if that's national or just a local one, but they kind of do some really good stuff for people who've got hearing and sight issues and stuff. Because that ultimately there might well be a need to actually have a worker of some kind with you to help you through the process. Also, councils have a duty to provide stuff in a kind of an accessible format. So if that needs to be large print or potentially braille, I don't know how that works in practice, but I thought they need to do it. So again, there might be some stuff the council should do. Karis, you got some more on this one?
Sorry, yeah. There's a lot of like screen readers on your phone, so it's like for whatever you're using, you've got like Windows have screen readers, so read the words off the screen. It's built into Apple devices. You've got JAWS for Windows as well. You've got text to speech tools, which you can speak into, and they'll read the letter to you. There's dictaphone and Word. If you're writing the letters and you want to put it, there's even Google voice typing. That's for Gmail and Google Documents. So there's loads of apps out there. Even if you can't see, there's and Charity, she said, and Citizens Advice will go through letters with you. But also the blind, there's Glaucoma UK charity that all works nationally, and you can get on the side of your phone or laptop or computer, there's digits that you can just press to get everything in large print. Sorry, that's probably a bit of a lot.
No, I think I think there's a lot of stuff out there actually for people to help them out. Just hopefully it's not sort of suffering in silence, because there might also be relevant stuff through the homeless application process. So, for example, the suitability of temporary accommodation, the number of times you get moved around would all be kind of take into account the fact that you've got partially sighted. So hopefully there'll be some stuff within all that would be helpful for people getting through it. I mean, let's be honest, it's hard enough to navigate it all anyway. So
yeah,
if you're struggling to read and stuff, it makes it just ridiculously hard.
This will be a good thing for if you need to record each meeting. You can just be like, everyone has a hard time saying, I want to record this meeting, but you can say, no, I have to record it because I'm blind. So it's really good for recording your meetings. So that's really good.
Yeah.
And on that, I wonder if it's like, if there's like charities like you just mentioned, Paris. I don't know if CAB do it, but that have like sort of advocates that can go into meetings with you and stuff, just to make sure that, like, if you're signing documents, like, sounds so boring, it's a legal process, right? If you're signing something but you can't read it properly, like, you need having someone with you I'd highly recommend it.
Yeah.
There's a quick question coming in the live chat, which I'll do now, but just to say I'm closing down the live chat for the time. Well, I'm not closing it down, but I'm not going to take more questions. But yeah, real quick one. So if an advocacy company is falsely advertising and refuse to help people when they meet the criteria written online, who can people complain to, please? So if it's a company, I'm not quite sure what you can do when it's a company, because companies aren't very very easy to hold to account. But if it's a charity, which I maybe think it's more likely to be a charity if it's doing advocacy, then you can complain to the chief exec, you can complain to the trustees. In my experience, when you've got a rubbish charity, the best thing you can do is complain to the funders, because that's when they really start paying attention, because they're like, oh, it's going to actually matter now. So yeah, and I guess it may be the case it's not necessarily false advertising. It might be that they're just full. So it might just be they've got no capacity. And so it might be that you meet the criteria, but they're just no one to go to. But I guess what we're talking about here is probably something else. Otherwise, the question, probably wouldn't come in. So yeah, hopefully, again, I think that would be my answer. Guys, if you've got anything to add to that, let me know. If not, we will do the final question we'll cover tonight, which is this one. So, hi, I've got Asperger's syndrome. I think that this means that the diagnosis got scrapped in 2013 and changed to autism. Will this make me automatic priority? It's honestly taken a massive toll, as in homelessness taking a massive toll. So the short answer is no, it's not an automatic characteristic. However, it's very, very possible indeed that it would basically mean that you would be considered vulnerable under the kind of definition of the Housing Act. Now, trying to think, there are some standard videos on this channel which kind of talk about that in more detail. There's a really good one where a judge called Sarah Steinhardt did a 30-minute kind of explanation about vulnerability and priority needs. So I think if you just Google, if you search for the judge explains priority needs on this channel, you'll find it. But I was delivering training in Glastonbury on Tuesday to some social workers, and actually I wasn't paying attention because one of the social workers asked a really good question, because she talked about, what sorts of things would be relevant to priority need. And kind of often when I talk about it a lot, I'm talking about medical issues, things, diagnoses, that sort of thing. But she immediately went off on a whole range of things that, we were talking about autism at the time, of how that would affect someone if they were homeless. And that's the key question when you're trying to show your priority need, is how is your impairment or how is your condition affected by the prospect or of actually being homeless? And so the social worker was talking about all sorts of cool things. I need to figure out a way of getting that. And I wonder if it might be worth us doing a standalone video at some time, given how busy we all are, but just kind of maybe get some social workers in to kind of talk about the sorts of things they would be assessing in their everyday kind of assessment when working with people with that diagnosis. Because I thought immediately there's a whole range of things which I hadn't really considered properly before that would be really, really kind of useful to take into account. So the short answer is it's not automatic. You have to show that it would mean you're vulnerable under the specific definition of the Housing Act. The fact it's taken a massive toll on you would be a good indicator that it is. But again, as the videos on the channel show, you need to do more than just say it is. You need to kind of go through a bit of a process, a bit of a definition of it to kind of get the answer. Yeah, and just a follow-up question, just the previous one about the advocacy company. The funders are the council. So still, it still might be worth raising with the council. I guess it also, again, just depends on the reasons why the company or the charity is given for refusing service. The funders are council, and the council stipulate they only do certain work. Though, are the funders allowed to stipulate a piece? Well, certainly the funders can say what their money's spent on or not. So the charity might then go and do extra stuff as well. That's fine. They're allowed to do that. But I guess the thing to say with charities is that there's no kind of the problem. One of the problems with them is that there is no kind of duties on them at all. So they don't have to really do anything in terms of positive stuff. They don't have to take people on. They don't have to do anything particular. They don't have to give a good service. They're just sort of there, and often charities get away with a lot of stuff that's just not okay. But that's one of the list of things that aren't very good in the world. So yeah, thanks guys. Thanks for your questions tonight, guys. Some interesting ones. I hope we've been helpful as always. I think, as I always say, I haven't got anything else to say really. All you can do in these situations is just keep persevering, keep finding stuff out. Hopefully the stuff we've gone through tonight will give you some kind of sort of understanding of the principles that underpin this anyway. And as we've said, in many cases, often you need to get a solicitor. It's just not realistic to expect someone who's never come across housing law before to suddenly start making these very kind of complex arguments. So yeah, check out the links we talked about on Will's website just to see if you can get someone with capacity. And if you can't, I guess the next best thing is to try and find a decent advocacy charity, or involve councillors and MPs and stuff. Because again, yes, some of them are useless, but some of them are actually really useful and can be really good. So, yeah. Any last thoughts from anyone tonight? If not, we will call it a night, guys. Thanks very much. We'll see you next week. Should be on Will's channel on Monday, 7:30 p.m. So if you haven't subscribed to Will's channel, do just search for it on YouTube. It's Will Flack Law, right? That's the actual name of the channel. I always get mixed up between yours and
I think it's
website.
W Flack Law channel. Let me check. I'll go W Flack Law channel.
I think it might be Will, but I don't know.
Yeah, it's William Flack Law channel.
Yeah, there you go. Yeah, so just search for William Flack Law channel, and we've been talking more sort of like general things on Will's session rather than specific questions, but we can take specific questions there as well. So, and in one sense, we've got more time to go into more detail then as well. So yeah, we'll call it a night. Thanks very much, guys, and we'll hopefully see you soon. Hopefully this has been useful.
Bye.